Mawena, Sedi has been in this country for some months now. You're a senior journalist. Did you get the benefit of verifying that she was not in Nsawam? At least, let's take me out of it, so that at least at the barest minimum, you will not be repeating such unfounded claims on TV.
We believe that the High Court judgment had merit. Now, with this judgment, I have also directed the Director of Public Prosecutions to file a notice of appeal and apply for stay of execution.
Abusia mamena wase na mema wakwa abasisi ade Ken Oforiata na damfo ayevra ne Sedina Tamakloe wanya ni freedom ade ntina me ka se Ken Oforiata na damfo Ghana memu ha na yewo na yembo yebra but omumienu de omo ye omo adwensisi ya oman Ghana mu ha de omo pese mo betena ha na omo dwane ye ekwohye US mountain so na Ghana mranso etimi do omo efamla kwan so ema Sedina Adionu Tamakloe de ye de ne bepie mu ewo oman Ghana mu ha ye de no kokogina court bene ya mene wo say court say yinya because nipa na wode no eba court no want me improve without any reasonable doubt enunti o hwe ne nsemu a onye boni bia enti yinya no Attorney General Dominic Ayini wababedi nkomo e dia fasa asemo no eho sanso na Edudzi Tamakloe a woye NDC lawyer ononso wababedi nkomo e dia fasa asemo no eho na mitie Edudzi Tamakloe ne nsem na wo kan any Attorney General de na Kame I say there is a big crasher between them. You look up here on video na answer no. Mesra unya subscribe na subscribe e dem amela ki video we na share mo no no so onya bi ehwe. Afi yenko nsemu kakra. Ye nyina ye nim de ekoso e wo ye ma Sedina Tamakloe nsensem yi ehum. NDC for omo nsem ba ko na de bi omo kan ene se Ken Oforiata wadi bone adwane akwakohye America mountain so ena MPB for so ka se ansa na Ken Oforiata be pim e wo Ghana memu ha no e wo se Sedina so NDC for etumi edeneba enti Attorney General woni US aban no edidi nkomo a ema atiunu de obedi Ghana memu ha ema ye de no kokogina court ena court ne ya mene wo ka se wodi na temu ababontin se wahwehwe ne nsimu nyina Bama meno onye boni bia because nipa na wode ne begina court no want me amfa reasonable evidence bia a money court say boni say e na waye eno ntie nyina so na yenjiri no ntina meno wo ekasi ya mama meno freedom na Attorney General Dominic Ayini ononso obabedi nkomo e dia fasa asem no say Supreme Court no and say appeals court no a wasete ma meno free no baabi ono omo enya because the predecessor na wo share asem na so no evidence na okuta no wogi this evidence no emu edu e wo se ma me itimi e punish no in this appeals court se wo jai na ono no de obesan for another appeal na Edudzi Tamakloe so TV3 for frɛ no ana omone no twetwem komo na wo kire mu se ne medikan kan ye no the way a court no o kan asem no say the order ne begina court want me improve say ma me no wadi boni bi no enti ono no de one court no ya adwen Edudzi wadi nkomo extensively on this particular matter sanso na Attorney General so wadi nkomo yenko na yenko tie nsem a omo aka mesero unya subscribe ya subscribe na wodan ho no na wakreke so e dia ma me like video we na share mo nua bi no so onya bi enwe me da wase nyankopon hira na wonkan.
This morning the Court of Appeal issued a decision unanimously acquitting and discharging Sedina Tamakloe, who was convicted of various offenses in absentia because, she was standing trial, and in the course of the trial, she sought permission to travel abroad for medical reasons and then remain in the United States for the rest of the trial. The trial court convicted her of the offenses charged, and then an appeal was filed by her lawyers in May 2024. I want this to be made abundantly clear that it was my predecessor who filed the appeal. However, coming into office, I reviewed what was filed, and I directed the Director of Public Prosecutions to file opposing the appeal, because we believe that the High Court judgment had merit. Now, with this judgment, I have also directed the Director of Public Prosecutions to file a notice of appeal and apply for stay of execution, meaning that if the stay is granted, the status quo will prevail until such a time that the Supreme Court has had time to review the appeal and then made a determination. So that is all that I can say for now. I have a soft copy of the judgment. I'm yet to peruse it and then come to a firm conclusion as to what will be our grounds of appeal. But I want to emphasize that I believe that the judgment of the High Court had merit, and that the United States District Court that extradited her to Ghana had a basis for making a determination that she was the proper subject for extradition. And that is all that I will say for now.
Let's go onto the phone lines right now and speak to Gordon Edudzi Tamakloe, who is the Director of Legal for the NDC, and quite interestingly, at one point in time, stood as counsel for her as well. Counsel, appreciate you. You're quite familiar with this case because you once served, like I was mentioning, as counsel for the now freed Sedina Tamakloe. Yes, Mr. Tamakloe, why are you saying something?
Can you hear me?
Yes, I can hear you.
Yes, I'm saying that good afternoon to your viewers. First of all, I've never represented her. I've never been lawyer for her as far as a case was concerned.
Absolutely.
I'm just speaking as a private legal practitioner, seized with some of the surrounding circumstances. Beyond that, I didn't have a personal conduct of the case.
Right. So let's zoom straight into it as well, because the suggestion is that it's been all very convenient, the manner in which things have played up until this point, this acquittal and discharge.
Once appealed, is reviewable by a panel of 3. That panel of 3 have every right to come to a conclusion different. And if you look at our jurisprudence, it is replaced. In fact, just a month ago, the Court of Appeal reversed a judgment on the narcotics case unanimously. And so this is nothing strange. The only challenge we have in this country is that usually when you are prosecuted, people do not want to see that your prosecution is based on what the individual is alleged to have been done. That in terms of group tax and what have you. But beyond that, I don't see anything so strange about the Court of Appeal reversing a judgment made by a trial judge at all.
Right. The argument is that this is convenient, particularly for her, and a bit too fortuitous, considering that she was returned to the jurisdiction. In fact, there were arguments as to whether or not she had been sent to prison to start off with, which drew statements from the Interior Minister, amongst other things, suggesting same had been done. And now she files an appeal on the 12th of this month, and the court sits, hears the appeal, and she's acquitted and discharged, when other cases, for instance, have been before that same Court of Appeal and yet to be heard.
Who am I speaking?
Mawina here, counsel.
Egbeto.
Yes, Egbeto.
Sorry. Oh, Mawina. Sedi has been in this country for some months now. You're a senior journalist. Did you get the benefit of verifying that she was not in Nsawam? At least, let's take me out of it, so that at least at the barest minimum, you will not be repeating such unfounded claims on TV. There's record, which record is easily ascertainable, that she had been in Nsawam prison. Is that a convenient proposition to make? With respect, if you have a situation where an appeal was mounted many times ago, many years ago, and submissions were filed many months ago, I don't know what you want done. Are you saying that you disagree with the judgment? A judgment that you and I are yet to read?
No.
What would be the basis?
Right.
And when the suggestion is made that it is convenient, What would be the basis of that claim of convenience?
Granted, and the point I make was in relation to the conversation surrounding before we got to know as well that she had been taken into prison custody. There was the conversation and questions being asked, but that's beside the point. The argument which has also been put forth by the minority, which is a criticism, is that with regards to the optics, it doesn't look quite good for the NDC who say they are engaged in oral, amongst many other things, for someone who's been convicted. Suddenly, the person has been acquitted as well. That's one of the many criticisms which is coming forth from your opponents.
The reasoning I get from your questioning is that it doesn't matter whether there was evidence to support the conviction. Once it meets a certain optical thing, it's enough to put the person in prison. Have you been in prison before? Have you spent a day in custody before?
Absolutely not, counsel.
So you can have that convenient conversation. You can have that. You can play balls with the liberty of an individual to satisfy a mob. I mean, that's your cup of tea.
Right.
It's stressful. If you have been in custody for even a day and you strongly believe that there's no basis for your conviction, even a day in prison will be the most horrible thing to happen to you. And let me say, have you even looked at the record of proceedings? Look, Sticker. You know Sticker?
Yes.
Sticker was a prosecution witness in this case. Under cross-examination, he was specifically asked, was one cedi paid by Sedina for those dances? His answer was no. And that he, as Sticker, was the one who came and renegotiated the contract. And this person is supposed to be in prison for that. Get the opportunity to read the entire record and see if those doubts in the prosecution's case ought not to be resolved in favor of the accused person.
Counsel, perhaps the final question I'll ask is in relation to the judgment, right, of Ifiasa Rebotwe on one of the counts of stealing, where the argument was made in the reasoning of the learned judge that in one of the instances where there was a claim of monies for sensitization and a specific workshop, some 1.7 million cedis, there was no evidence as to the workshop being done. Prosecution argued that even the regional officials and all of that could not verify if the workshop or the sensitization exercise had been carried out. And her absence to have been in court to prove that indeed it happened, because the burden had shifted from the prosecution to her absence constituted a part of the reason why she couldn't disprove that prima facie evidence which had been placed on her. That argument has been made that her absence as well could have gone against her in that trial.
Look, the burden is still on the prosecution to prove her guilt beyond reasonable doubt. They failed to do that. Let me go back to the records. And because you raised the issue of records, if you look at volume 5, page 64 of the records, this is the exchange that happened between the prosecution witness and counsel for her. Question. The officers who wrote statements indicating that they were sent to cash checks and handed over the monies to A1 did not indicate that there was no sensitization. Is that correct? Answer. That is correct, my lady. Do you still stand by your claim?
Well,
do you still stand, from what I just read and across, do you still stand by your claim?
Then that will prove, amongst many other things, perhaps the basis upon which the Court of Appeal has arrived at that decision.
What are you talking about? You have not even adverted your mind to the record.
No, I have read the judgment.
It's like a bull in a china shop. Go back to the records. The prosecution witness were specifically asked that none of the officers indicated that there was no sensitization. And the answer by the prosecution witness was, yes, my lady.
For you, that disproves their case completely.
Based on your claim, does it not controvert your assertion?
Well, it will suggest same, will it not?
So if there is a doubt from your learning, when should the doubt be resolved in favor?
Well, counsel, appreciate their insights and the details, and we'll look forward to.
Please, you say we should go back to the records.
Right. Certainly. Appreciate you speaking to us. That's Edudzi Tamakloe. He is Director of Legal of the NDC, speaking to us this afternoon in relation to the acquittal, right, and discharge of Sedina Tamakloe in relation to that case brought against her, convicted, sentenced to 10 years. The Court of Appeal acquitted and discharged her. Looking forward to the full reasoning. We understand is a 94-page reasoning of the Court of Appeal, which says that the prosecution did not discharge the burden of proof in relation to the charges brought against her, resulting in an overturning of the ruling.